The next matter to come before the court this morning is William Horton versus Valerie Horton. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If the appellant wishes to reserve any time for rebuttal, let me know when to get started. I'm keeping track of the clock and can let you know if you're getting into your rebuttal time and if reserved, and you can also keep track of the clock on the wall. Please don't use the names of any victims or minors. I don't know that it's relevant here, but we make that advisement because this is being recorded and will be posted on the court's YouTube channel. We've read the briefs, we're ready to proceed when you are. Would you like to reserve any time for rebuttal?
I would, Your Honor. 5 minutes.
Certainly.
Thank you. I'm Charles Tyler Sr., representing Mr. William Horton. Mr. Horton on March 2nd, 2021 filed a motion to modify his spouse support. On May 11th, a hearing on plaintiff's motion to defendant's motion to modify spouse support was held. On June 17th, the magistrate issued an order modifying the appellant's spouse support. On June 28th, appellee filed an objection, and the judge issued a ruling sustaining the appellate's objection. During their divorce, they had a separation agreement that provided how spouse support was to be paid, that the court retained jurisdiction. Mr. Horton, at the time the divorce, was working as an executive with Mr. Chicken, making $88,000 a year. Sometime after that, the organization made a reorganization. They offered him a job as a store manager for $32,000, which would have been almost a $56,000 pay cut. Instead of taking that pay cut, he opted to own a Zoop shop. In fact, he opted to own 2. That was in 2019. Unfortunately, like many other restaurant owners, Mr. Horton did not have a crystal ball, did not know that in 2020 that COVID was going to come to the U.S. and almost cripple all food places. So, of course, his 2 businesses was impacted by COVID. Didn't make the money he would have made but for COVID. Even Mr. Chicken, where he was working before, was impacted by COVID. The magistrate did not find that he was voluntarily underemployed. And that's why I believe she found that there was a change in circumstances as the law required. There was a significant change in his income, and she granted his motion to modify. The judge later on, I think, found that he made the decision to leave his job and all those kind of things. Fortunately, in America, we have the right to own businesses and work in different places. The divorce decree never said he had to stay there. He made a business decision that was a good decision at the time, and again, unfortunately, was impacted by COVID. The court said that it didn't have jurisdiction, but clearly the divorce decree said that the court retained jurisdiction to modify the amount and duration, so the court could have modified the spouse support. We believe it was an error when the judge said that there wasn't a change in circumstances, he was voluntarily unemployed. He was not, clearly was not, and they had the opportunity, the authority to modify, and they did not, and that's basically my argument as best I can. Not feeling well, but did the best.
Thank you, counsel. You'll have your full 5 minutes for rebuttal.
Good morning. I'm Melissa Graham-Hurd. I represent Valerie Horton in this appeal brought by her former husband, William Horton. I will apologize ahead of time. I have tinnitus, and I may not hear exactly what your questions might be. I want to engage in conversation with the court about this 9-year marriage that terminated with a separation agreement between husband and wife for division of property as well as payment of spousal support. They had a 2-tier system that they devised in their separation agreement, which is not unusual, where people's compensation from employment comes at a bonus, which is not within their control, is at the whim of their employment. In order not to calculate the support that would be due each and every month, they agreed to set aside the bonuses. and divide those if they occurred and when they occurred. But the base salary was used as the starting point for comparing their relative incomes and all the other factors listed in 310518 for payment of spousal support. And the parties determined that the appropriate amount was $1,200 per month for a 29-month period. That's a fairly short period of time. Because it was such a short period of time, a definite amount for a definite period, and because there was some question as to whether or not Williams' employment would continue to be base salary plus bonus, the parties included a clause that would permit the change of their base plus if and when bonus payment if the employer changed the method of payment. For example, if he had a raise and he no longer got bonuses, then the $1,200 a month could change. That's not what happened here. What happened here was post-COVID, it was not during COVID, post-COVID, Mr. Horton decided to leave his employment voluntarily. He quit. There was no unemployment compensation. There was no showing that he was terminated. There was no showing that he was laid off. He voluntarily quit, opened up not 2 but 3 Zoop franchises as time went on. Certainly every business had difficulty during COVID, especially restaurant business. But there were so many governmental supports for businesses. I listed them in the brief.
How do you get around the language if for any reason husband has a change in method of his payment of base wages?
Method of payment.
So method is the key you're honing in on that, if for any reason he changes? Because if any reason would it mean voluntary?
I don't believe that's the spirit in which it was meant.
Okay.
When we look at contract interpretation, we're to look at the intent of the parties. If the method of payment changes for any reason, quitting your job is, I guess, a method of payment, but it would be no payment then. I don't believe that that would be a qualifying event, and neither did the trial court. The trial court felt that it did not have jurisdiction to modify, given the limited circumstances under which the parties chose their own language in their contract to reserve jurisdiction under such limited circumstances.
When it then says in the very next phrase that the court specifically retains jurisdiction to modify the amount and method of payment of spousal support.
Again, that follows the if.
Yep.
If. So a very small circumstance, a condition precedent, if you will, to give the court the jurisdiction to make a change. So the fear was, the baseline was $88,000 salary. As it turned out, he made $92,000, and the base amount did not raise. So if instead of $88,000, he made $100,000 in fewer bonuses, then the base amount could change based upon that fear that the employer would change his compensation structure. It would be a very bad precedent if people who were obligors under support contracts that they themselves make, to be able to say, oh, forget it, I'm going to quit my job, I'm going to be an entrepreneur, I'm going to start my own thing, never mind the promise I made and the contract I made with my former wife, my former spouse, that I would pay monthly spousal support. I'm just not going to pay anything.
Well, the question of whether or not someone's voluntarily underemployed or unemployed is separate than the question of jurisdiction, the court's retention.
Of course.
I didn't know in either brief that there was some case law about that, about whether or not when the court retains jurisdiction to modify spousal support, the court
sorry, I'm not following.
Yeah. I wasn't very clear, so I'm not surprised.
I apologize.
No apologies needed. I didn't see any case law specifically that said if the trial court retains jurisdiction, we don't talk about any of the other factors. In other words, a retention of jurisdiction for spousal support is just what that is. Because we're talking about jurisdiction, not whether or not someone's underemployed or
Yes.
unemployed or did a bad thing.
Well, no doubt about it, it is a two-tier approach, that before the court can modify, it must determine that it has the ability to modify by retaining jurisdiction to modify support. If it fails to retain jurisdiction, these many dollars for this long period, the end, then there is no modification. It cannot happen. It cannot happen. Whether or not whether you move to tier number 2, question number 2, should support be modified, and if so, using the factors in 310518, what is reasonable and appropriate under these changed circumstances? You don't even get there. You don't pass step number 1 if there's no jurisdiction to modify. The intent of the parties was to have a set amount for a short period of time, 2 years and 5 months. For such a short duration of spousal support, it's not unusual at all to have a definite term, a definite amount, not modifiable. But under these narrow circumstances, because of the question of whether or not William's employer would change his bonus structure, and therefore perhaps Valerie would be entitled to a larger amount of base spousal support rather than relying upon tier 2 for the bonuses, which of course were never paid.
So it could only modify up, not down?
No, I believe it could be modified down should the employer have cut the base salary and relied more upon bonuses, commissions, other compensation, I think is the word used in the decree. Other compensation instead. And it wasn't an accommodation, the husband. It was recognized that he would have insufficient cash flow should his income from all sources be considered in determining the amount of spousal support. If for any reason husband has a change in the method of his payment of base wages, bonus, or severance, then the court retains jurisdiction to modify the amount and method. So it could be wiping out level 2, making it all level 1. I believe I'm over my time. Thank you for your attention and your questions.
Just a few things. Number one, it needs to be clear that COVID started in 2020, and this business of my client started in 2020. In fact, in the brief, it says that he testified that he earned $15,579 in 2020, and so far in 2021. So this was during COVID. And as far as talking about method, he was a regular employee who received W-2 wages. When he started his business, he was no longer a W-2 wage earner. So there was a change in his method of payment. Second of all, as related to the contract, when there is ambiguity, the ambiguity is held against the drafter. It was the plaintiff who filed for divorce. It was her attorney who drafted the contract. So if there's any ambiguity according to contract law, it should be against her because she was the drafter of the contract. Again, clearly my client was not voluntarily underemployed. He's no different than any other people. The sad fact, even in our community today, we still see restaurants closing today because they have not recovered from COVID. And talking about bad public policy is to have someone stick to a job just because they're afraid if I go to another opportunity and something happens, I'm going to be stuck with a spouse because I couldn't pick it. It's bad policy. Again, The guy's not underemployed, the agreement said it could be modified, he applied for the modification. Magistrate said it should have been modified downward, and we asked that the court would overrule the objection that was sustained by the judge. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed by the clerk of courts to all parties to this appeal. It will also be posted on the Supreme Court website. Thank you
Thank you.
both.